Men Olson, 27, 21, Nickel Avenue, 707-951-1619. In pro per Christine Marie Olson, plaintiff Michelle Nicole Olson, defendant California Superior Court County of North Butte Deer Honorable Judge Candela Case No. 218000223 Re. Motion to reopen DVRO case. Request for subpoena. Request for communication with 1. Edmund D. Edelman's Children's Court. 2. Safe at Home Program. Secretary of State. Declaration in support of the motion to reopen DVRO case. Memorandum Division. FAM date, December 6, 2023 time, 8:30 a.m. Judge, Candela, Michael Ree. Motion to reopen DVRO case. Request for subpoena. Request communication with 1. Edmund D. Edelman Children's Court. 2. Safe at Home Program and the defendant's declaration in support of the motion to reopen. I am writing to respectfully request the reopening of the DVRO case between Michelle N. Olson and Christine Marie Olson, Lure, bearing the case number 21 FL00223 filed on February 22, 2021 and obtained permanent orders on the date of May 6, 2021, qualifying for a 3-year term. Punishment, restraining order. After hearing held by Judicial Officer Melian, Sandra L., commenting on the expiry date of May 5, 2024. I have never been provided with this final order. As online, it appears the case has been closed on an unknown date, and I believe that there are significant reasons to review and reconsider the DVRO placed against me. Background: on May 6, 2021, a domestic violence restraining order, DVRO, was issued against me based on the false and unfounded allegations made by Christine Olson, Lures. The DVRO was granted for a 3-year term, expiring on May 5, 2024. Grounds for reopening newly discovered evidence. Since the closure of the case, I have obtained new evidence that was not previously available during the initial proceedings. This evidence includes a. Witness statements, affidavits from multiple witnesses, including Aaron Lyons, clinician supervisor of the Butte County Behavioral Health, Paul Tim, Jeremy Doreen Kaler, individuals who were present during the incidents mentioned in the DVRO. These witnesses can attest to the fact that the events described in the DVRO did not occur as alleged by my sister with malice intent for the upper hand in guardianship/adoption cases and my actual innocence. B. Documentation, documentary evidence, such as text messages exchanged between Christine and me. Requested documents from the clinic, etc., which substantiates that the allegations made against me were false and without merit. Procedural irregularities. There appear to be procedural irregularities during the initial case proceedings, which may have affected the outcome and closure of the case. These irregularities include a. Incorrect hearing time provided by the clerks and hours of operation of the NBCCH displayed online. On the date of the original hearing, I had appeared for the scheduled hearing at the North Butte County Courthouse, relying on the information provided by the court clerks and hours of operation displayed on the official web page for the NBCCH. However, upon arrival, I was informed that the hearing had already taken place earlier that day, by only a few minutes, and I was not present for it. The court clerks had erroneously provided me with the wrong hearing time, which resulted in my inability to participate in the proceedings and present my defense. Furthermore, the misleading hours of operation for the courthouse had done the same. B. Denial of due process. Due to the incorrect information provided by the court clerks and misleading hours of operation for the courthouse, I was denied the opportunity to be heard and defend myself against the allegations made by my half-sister, petitioner, Christine Olson, Lure. Communication with Edmund D. Edelman's Children's Court, LA County. Additionally, I am aware that Christine Olson, Lure, has filed a separate case in LA County Court in an attempt to declare my children free for custody. I request the court's permission to communicate with LA County Court to obtain relevant information about the case, as it may impact the DVRO matter as well as the contested adoption case. Pursuant to California Family Code Section 3027.5, communication with another court is allowed in situations like this, where a party is asserting willful failure to communicate. Communication with the Secretary of State Safe at Home Program. Furthermore, Christine Olson, Lure, has fraudulently enrolled in the Safe at Home Program as administered by the California Secretary of State. I request the court's permission to communicate with the Secretary of State to verify the authenticity of her enrollment and any misrepresentations made therein. Legal remedies sought. If the court grants the reopening of the DVRO case, I am seeking the following legal remedies. Vacate the DVRO, pursuant to California Family Code Section 6345, which allows for the termination of a DVRO if it was issued based on false or insufficient evidence. I request that the court vacates the existing DVRO that was erroneously issued against me. Full hearing. Under California Family Code, I am entitled to a full evidentiary hearing to present the new evidence and challenge the allegations made by Christine Olson, Lure. Sanctions. Pursuant to California Family Code Section 6342, if the court determines that Christine Olson, Lure, has acted with malice or made false statements to obtain the DVRO, I request that appropriate sanctions be imposed. Request for subpoena. In support of my defense, I respectfully request the issuance of a subpoena for the records of Butte County Mental Health Facility, where Christine Olson, Lure, claimed I demanded my children back from staff. Pursuant to California Evidence Code Section 1045, these records are expected to contain relevant communications, appointments, or any interactions involving my sister, myself, and my children. I believe that these records are crucial in providing a comprehensive and accurate understanding of the events in question. Charge Christine with malicious prosecution. In addition, I request the court to consider charging Christine Olson, Lure, with malicious prosecution if it is determined that she pursued the DVRO with malice, knowing the allegations to be false. Malicious prosecution involves the wrongful initiation of legal proceedings with the intent to harm, and such charges would serve to discourage baseless legal actions and ensure accountability. Visitation and communication with my children. I request the court to grant me visitation and communication rights with my children, Ivy Olson and Lila Olson, to ensure a meaningful and ongoing relationship. Such rights are crucial for the well-being and emotional development of my children. Custody of my children back. I request the court to reevaluate and modify custody arrangements with the ultimate goal of restoring full custody of my children, Ivy Olson and Lila Olson, to me. This is in the best interest of the children, considering the new evidence and circumstances that have come to light. Restraining order on Christine Luer and Adam Luir. I request the court to issue a restraining order against Christine Olson, Luer, and Adam Luer, prohibiting them from any contact or communication with my children, Ivy Olson and Lila Olson, and designating them as protected parties. I believe this is necessary to ensure the safety and well-being of the children. Any other remedies deemed necessary and appropriate. I acknowledge and request the court to consider any other legal remedies or measures that it deems necessary and appropriate in light of the circumstances presented in this case. The goal is to ensure a fair, just, and equitable resolution that prioritizes the well-being of all parties involved. Conclusion. In the interest of justice and to ensure a fair determination of the DVRO matter, I respectfully request that the court grants the reopening of the case. I believe that the new evidence, procedural irregularities, communication with Los Angeles County Court, and communication with the Secretary of State regarding the Safe at Home program warrant a fresh examination of the case. Furthermore, the consideration of pursuing charges of malicious prosecution, addressing visitation, custody, and restraining orders, along with any other remedies deemed necessary and appropriate, are essential components of a just resolution. Thank you for your attention to this matter. I look forward to the court's response. I declare under the penalty of perjury the foregoing is true and correct. Respectfully submitted, Michelle Olson, defendant in pro persona. Declaration of Michelle Olson. Dear Honorable Judge, I, Michelle Olson, urgently bring to your attention a matter of utmost gravity involving the unjust issuance of a domestic violence restraining order, DVRO, and the subsequent false guardianship of my two children orchestrated by my sister, Christine Luer. My purpose is to express profound concerns about fraudulent actions that may lead to the irreversible loss of my parental rights, seeking the court's immediate intervention to rectify the injustices I have faced. Background. In 2021, a default judgment was issued against me in a DVRO case initiated by Christine. This judgment resulted from a significant misunderstanding during the hearing, and I maintain my innocence in the matter. The impact of this DVRO has been far-reaching, severely restricting my ability to communicate with and locate my beloved children. Fraudulent guardianship and adoption proceedings. The circumstances leading to the false guardianship of my two children are distressing. During a crisis, I approached Christine to temporarily care for my children, and we mutually agreed to a 6-month arrangement. Less than 30 days later, Christine clandestinely filed for legal guardianship with court involvement, violating our mutual understanding and previous verbal promise not to involve the courts. She underhandedly forged my signature on the GC-211 consent and waiver of notice, granting her a 6-month head start before I became aware of the situation. This act of forgery and deception allowed Christine to gain legal guardianship without due process. In retaliation to my second attempt to terminate the guardianship, Christine escalated matters by filing to declare my children free for adoption. The cases were consolidated and transferred to LA County, where my attempts to terminate guardianship have been systematically ignored, placing my parental rights in imminent jeopardy. Manipulative Safe at Home restrictions. Compounding the complexities, Christine manipulated the legal system further by enrolling herself, my children, and her husband in the Safe at Home program through the Secretary of State. This strategic move has severely restricted my ability to maintain any form of contact with my children. The Safe at Home program, intended to protect victims of domestic violence, has been used to shield my sister's actions and unjustly restrict my parental rights. As a result of this enrollment, I have been rendered unable to ascertain my children's whereabouts or engage in any form of communication with them for the past 2 years. This restriction, exacerbated by the DVRO, has created an insurmountable barrier, leaving me in the dark about the well-being and living conditions of my own children. Confusing legal process. Complicating matters further is the confusing legal process dictating that I must terminate the guardianship through a probate court, even though my children no longer reside in Butte County and have been made aware that they no longer reside in LA County, informed by Edmund D. Edelman's Children's Court. The very essence of this requirement becomes an impracticality given that I am not privy to their current residence whereabouts due to the restrictions imposed by the fraudulently obtained domestic violence restraint order and false enrollment at home program. The current legal landscape leaves me in a state of disarray, with no clear path to follow to protect my parental rights. The intricacies of the legal process, coupled with the deliberate confusion caused by conflicting requirements, pose a substantial challenge in my pursuit of justice for my children and myself. False accusations of willful failure. My sister, Christine Luer, is currently alleging willful failure on my part to communicate and support my children. This accusation is particularly egregious, considering the circumstances imposed by the DVRO and Safe at Home program. The mechanisms put in place to protect victims of domestic violence have been weaponized to prevent me from communicating with my children and providing any form of support. I emphasize that the DVRO and Safe at Home restrictions have placed me in a situation where communication is legally prohibited. Furthermore, I wish to highlight that I possess a child support order, leaving me legally unable to provide financial support. These allegations, when viewed in the context of the constraints imposed upon me, reveal a blatant attempt to terminate my parental rights through a false narrative. Illegal adoption proceedings, and false DVRO allegations. It is imperative to note that if the adoption is granted, it would have been wrongfully done and illegal. Additionally, the dvro is based on false allegations orchestrated by Christine and her husband, Adam Luhr, for an event that never took place. There is no record of the alleged event, and coupled with this concern and fact that Christine was 40 minutes away in Red Bluff on the day she claims I was demanding my children back from the staff of the Butte County Behavioral Health. This difference underscores the fabricated nature of the story. Furthermore, I wish to bring to the court's attention additional false allegations made by Christine, including claims of stalking and communication from an individual named Brian, which I vehemently deny. I have a witness who was with me during the entire time Christine alleges these events occurred. The assertions made by Christine are baseless, and I have never been involved with anyone named Brian since middle school. And never have I attended a program in which I do not need. These false accusations further emphasize the urgency of the court's intervention. The egregious nature of these actions, coupled with false allegations, underscores the urgency of my plea for the court's intervention. I am prepared to present evidence supporting these claims and request a thorough examination of the circumstances surrounding the false guardianship and impending adoption proceedings. Your prompt attention to this matter is sincerely appreciated. Michelle N. Olson, dated this 8th day of November 2023.